Request all of you to please be seated. Minister has arrived. He'll be coming shortly. The Law Minister has arrived. Request all of you to please be seated. I request the Chief Guest, the Law Minister, Mr. Arun Chawla, Mr. Philip J. Ratnam, to please come on stage. Ms. Anjurati Rana, Justice Sikri, Good morning, distinguished guests, ladies and gentlemen. I, Bhumika Indulia, and it is my absolute pleasure and honor to welcome you all to the Indian Council of Arbitration Symposium cum Roundtable discussion themed on bridging markets, resolving dispute via ADR in the India-Singapore corridor. With over 60 years of leadership in institutional arbitration, the ICA has been at the forefront of promoting ADR as the preferred mode of dispute resolution, both in India and globally. Recognized for its pivotal role in shaping the arbitration landscape, the ICA has administered claims exceeding $470 million, delivering on the principles of cost and time efficiency, while actively championing diversity through its dedicated panel of female arbitrators. This symposium comes at a pivotal moment as India and Singapore deepen their strategic and economic engagement following the recently concluded Third India-Singapore Ministerial Roundtable earlier this month in New Delhi, marking 60 years of diplomatic ties and 10 years of their strategic partnership. The dialogue primarily focused on enhancing collaboration across digitalization, sustainability, and capital market. The theme for today, Bridging Markets through ADR, resonates strongly with this evolving partnership, offering a framework for smoother cross-border commerce and reinforcing investor confidence in India-Singapore economic corridor. We now move to the felicitation of our chief guest for the event. At the onset, let me take the opportunity to welcome our chief guest for today, Shri Arjun Ram Meghwal, Honorable Union Minister for Law and Justice, Government of India. We are honored to have you, sir. I request Dr. N.G. Khetan to kindly felicitate Shri Arjun Ram Meghwal ji with a green certificate. Thank you so much, sir. I now invite Mr. Arun Chawla, Director General of ICA and former Director General of FICCI, to welcome the gathering.
Esteemed guests, distinguished judges, eminent lawyers, and friends from India and Singapore and beyond. Ladies and gentlemen, on behalf of Indian Council of Arbitration, it is my privilege to welcome you to this ICA Symposium on bridging markets, resolving disputes via ADR in the India-Singapore corridor. Today's gathering reflects a shared commitment between the two jurisdictions that stand at the heart of Asia's economic and legal landscape. Singapore has long been recognized as the global hub for arbitration and mediation, while India in recent years has undertaken significant judicial and legislative reforms to strengthen its arbitration framework. Together, our countries are uniquely positioned to co-create dispute resolution systems that address the growing complexity of cross-border disputes while setting new global benchmarks. Ladies and gentlemen, we are privileged by the presence of Shri Arjun Ram Meghwal, Honorable Union Minister of Law and Justice, Government of India. Honorable Minister, your travel to Singapore for this symposium is a testament to your commitment to ease the dispute resolution process between the two jurisdictions and further enhance bilateral trade and investment between the two countries. Ladies and gentlemen, we are also honored by the presence of Honorable Justice A.K. Sikri, former judge of the Supreme Court, and now the international judge at the Singapore International Commercial Court. Justice Sikri, you have made a remarkable contribution in bringing the two countries closer in terms of juridical processes. Ladies and gentlemen, we are equally honored by the presence of Honorable Justice Philip J. Ratnam, President of the Singapore International Commercial Court. Justice J. Ratnam is a distinguished jurist and was, prior to becoming a judge, one of the Singapore's youngest senior counsel with a celebrated career spanning the bench, top-tier legal practice and public service. A former ASEAN CEO of Dentons and an award-winning author, he exemplifies excellence in both law and multidisciplinary achievements. Ladies and gentlemen, we are delighted to welcome a surprise guest of honor, Dr. Anju Rathi Rana, Secretary at the Department of Legal Affairs at the Ministry of Law and Justice, Government of India. She stands apart as the first woman to be the Union Law Secretary, having broken the glass ceilings with a perseverance, hard work, and professional competence. Our gratitude also extends to Dr. Shilpa Kambule, High Commissioner of India to Singapore, someone who's known to have enriched the contours of India-Singapore trade and legal diplomacy. Ladies and gentlemen, please join me in welcoming the dignitaries on the dais with a thumping round of applause. Ladies and gentlemen, India and Singapore have indeed embraced change through structural legal reforms, new economic visions, and progressive arbitration regimes that respond to the needs of the 21st century. Our bilateral economic relations have entered a new era, with Singapore serving as the key partner in India's Act East policy, as India and Singapore deepen their strategic and economic engagement following the recently concluded third India-Singapore Ministerial Roundtable held earlier this month. The momentum is unmistakable, marking 60 years of diplomatic ties and 10 years of this strategic partnership. The dialogue stands as a unique bilateral mechanism that reflects the robust, multifaceted, and forward-looking relationship between the two countries. This symposium, ladies and gentlemen, is more than a conference. It's a platform for institutional collaboration, knowledge sharing, and building confidence among investors, regulators, and businesses that rely on clarity, speed, neutrality in dispute resolution. I'm confident that the conversations today will not only strengthen the India-Singapore ADR practice dialogue, but also contribute meaningfully to the wider Asian dispute resolution ecosystem. With that, it is my honor to welcome you once again and invite the President of Indian Council of Arbitration, Mr. N.G. Khaitan, to deliver his opening address.
Suprabhat. Good morning, Singapore. Good morning. Say good morning at least. Good morning. Good morning. I wouldn't say it's a coincidence. Indian Council of Arbitration was established in 1965. You got your independence in 1965. So happy independence to Singaporeans and happy interstate to Singapore. And happy birthday, 60th birthday to ICA. So it's a, what is ICA? I mean, today we are here for the first time. But let me tell you what we are doing and how are we promoting arbitration. Just give you a history of last 8 months. We were in Australia in the month of November, and we had the privilege of addressing the parliament, and we had the external affairs ministers with us. Then we were in Riyadh in the month of March, where we had the Honorable Law Minister and Honorable Attorney General of India with us. Then in the month of June, we were in London, where we had the Chief Justice of India, we had the Honorable Law Minister of India, we have the Judge of the Honorable Supreme Court of UK, Justice Briggs, apart from, we had an attendance of over 500 people in our London conference. And today, on your 60th Independence Day, we are here in Singapore. So this is what I wanted to tell you what ICA is all about. Now, if you ask me that why we have, India was not so much known for an arbitration internationally, but let me tell you, the mediation and arbitration has been in Indian blood for centuries. It's for centuries. I mean, let me tell you very honestly that today also, if there is a dispute between the families, then it's somebody's senior member in the family or somebody's senior member in the society, without approaching the court, try to resolve their disputes and differences. This has been the culture in India. The culture in India has been to resolve disputes. The culture in India has been to live in a very peaceful and congenial manner. You will be surprised to know that, you had the codified arbitration law a few years back, but we had the first arbitration codified law in 1781. So you can understand, since 1781 we have been arbitrating in India, 1781. The Britishers introduced arbitration in India. Many acts came into force from time to time, making improvements. And the other act came in 1840. Then there was a first act called as the Indian Arbitration Act, which came in 1899. So I'm not going into the current act because our law, arbitration law, and your arbitration law are basically based on unilateral model. We are a common law country. But why are we in Singapore? Singapore is one country which has been rated by SP having triple A, AAA. And there are two countries in the world only which has AAA. The one is Singapore and the other is Germany. This is what Singapore is today. This place where we are holding a conference today was a post office. I think Mr. Xavier would know that this was a post office. And today you have converted this hotel into one of the most iconic hotels in the world. This is what Singapore is. Singapore, for Indians, if you have seen an Indian movie, there was a song which said that, Jivan mein ek baar aana Singapore. Come in your life, come to India once in your lifetime. And that was a very famous song. And we Indians love Singapore. I don't know how many tourists comes to India, but more than 10 cities are directly connected, air traffic directly connected with Singapore. More than 10 cities in India. Millions and millions of tourists from India, they come to Singapore. If a millionaire or a billionaire has a choice to move anywhere in the world apart from India, their choice is either Singapore or Dubai. So this is what Singapore is all about. So this is why we consider Singapore as one of the best countries to do business with, one of the best countries in the world to come and arbitrate. The issue is what is India today? Just on 3rd of August, somebody said that, somebody very important, that India has a dead economy. But let me tell you, in last 20 days, what the rating agencies all over the world think about India. It was on 14th August itself. 3rd August we said that India has a dead economy, and 14th August itself, after 18 years, the sovereign rating of India was upgraded. And that rating agency was S&P, as you all know, one of the most prominent rating agency. And he also gave a very startling figure, which was also not known to me, that between 2022, just after COVID, between 2022 and 2024, India grew at 8.4%. Unbelievable. Total transformation after COVID. And their prediction is that India will grow for a long term over 6%, and their growth will be highest in the world. Not for 1 year or 2 years, but for many, many long years. Then again after 2nd of August 2025, there was another rating agency, you must have heard of him, IMF, International Monetary Fund, though controlled by America. And Morgan Stanley, again from America, they said that India is a global growth leader. India is a global growth leader, contributing to 16% of the global growth. I'm not saying so. These are the rating agencies, well-known rating agencies all over the world, they are saying so. And then there was a PwC report immediately thereafter. They went to say that India would have a 9.3 trillion economy by 2030. I mean, people always say we are largest economy, we are the third largest economy in purchasing power parity, largest consuming power, third largest. I don't want to go into all those issues that we are the manufacturing hub of the world. In fact, we are the fifth largest manufacturing hub of the world. But I don't want to go into all these. I wanted to say what world thinks about India, how the world perceives India. And then recently, the World Economic Forum went on to say that this is very important, that India tops in the chart, in trust, which is very important, in trust, because you cannot do business unless you don't trust each other. So India tops the chart in trust, it tops the chart in doing business, it tops the chart in NGO, it topped the chart ranking 5th, that you can trust the government, and it ranks 4th in trust amongst the media. Media is very important. You must know, people in the country must know what is happening in the country, how the government is functioning, how the opposition is behaving, what people think about your country. This is what India is all about. I don't know whether you all people have seen a movie called Godfather. There was a movie called Godfather, Marlon Brando was there. He made a very bold statement, sir. He said that if you have a gun, and the person on your other side is empty-handed, you can slaughter him. He is absolutely at your mercy. But if you have a gun, and if I have a gun, if you have a gun and I have a gun, I can demand justice, I can demand fairness, I can demand law. Today, India has a gun in its hand. Nobody can bully India anymore. We are the 4th largest military power in the world. We are the 2nd largest army in the world. It's a time for you to trust India. Between, just small figure, between 2016 to 2024, these figures are basically unknown. People don't know these figures. We were able to resolve through mediation 700,000 cases. 700,000 cases. Last year, in the High Court all over the country, we were able to dispose of 1.2 million cases. You can see the experience which the judges in India have, the experience which the lawyers in India have to deal with so many branches of law, so many cases. I would say it's one of the most experienced countries in the world as far as the law is concerned. Sir, in fact, our Honorable Law Minister is here. he recently announced a national litigation policy to promote arbitration and mediation. Our present Chief Justice, Justice Gawai, and the incumbent Chief Justice, Suryakant, he said mediation for the nation. The word was mediation for India, mediation for the nation, to resolve all commercial disputes. Sir, if I may say so with utmost respect, that we took up a challenge to reform, perform, and transform. And I'm proud to say that today we have transformed ourselves into a golden India. I would also urge, I know that the Singapore is the most trusted venue of arbitration, most preferred destination for arbitration. People flock to Singapore to arbitrate. Indians flock to Singapore to arbitrate. But I'm here to also tell you, give us a chance to India. We will not fail you. You can trust us. We will just not fail you and give you a speedy and a cost-effective arbitration and mediation. Thank you very much. Thanks a lot.
Thank you, Dr. Khetan, for laying a strong foundation for today's deliberations and also of reminding us of a song, Jeevan Mein Aana Ek Baar Singapore. It set the tone for today's discussion. Ladies and gentlemen, to set the tone for today's deliberation, it is only fitting that we first hear from the representative of India in Singapore, who plays a pivotal role in nurturing this vital bilateral partnership. May I now invite Dr. Shilpak Ambule, High Commissioner of India to Singapore, to deliver his address.
Very good morning to all of you, respected Honorable Minister, all the distinguished dignitaries on the stage as well as in the audience. I am not from a legal background, so I'll just briefly touch upon what's happening in India and Singapore over the last 1 year and why this particular month and this week has been especially busy for us. Prime Minister Modi ji visited here in September of last year. We celebrated 10 years of our strategic partnership, and we agreed to elevate it to a comprehensive strategic partnership. And I tell you the reason why. We had concentrated and saturated the traditional areas of collaboration. And so we decided to focus our attention on 6 new pillars of our partnership. First and foremost was the digital space. We have the UPI Pay Now link here, which is used both for remittances as well as merchants payments. And we are expanding more banks to be onboarded both on the Singapore and the India side. The second area is skilling. Singapore, as we all know, has a very good competitive advantage in this field. And we are trying to see if we can develop similar models back in India, both at the national level and the state level. One prominent example is the World Skills Center in Bhubaneswar, Odisha, which the Singaporeans have built and are even operating. We are trying to expand it to different states as of now. The third area is advanced manufacturing, both semiconductors and electronics. We know Singapore has really built a very nice and efficient semiconductor ecosystem here in Singapore. They produce 10% of the world's semiconductors and 22% of the semiconductor equipment. We in India have embarked on our semiconductor journey and have decided on locations in Gujarat, Assam, and a few other states. So Singapore is helping us to build that ecosystem. The fourth area is connectivity, both maritime and air connectivity. We are soon going to sign a green and digital shipping corridor between Singapore and India. And we are also trying to expand air connectivity. To the earlier point, Singapore is connected to 18 Indian cities. And so we are trying to promote tourism flows both towards India and into Singapore. Another area of collaboration is the whole health sector. We are trying to see if we can get our generics medicines into Singapore and learn from some of their best practices. And the sixth pillar which was identified was sustainability and green growth. We are trying to collaborate in green ammonia, green hydrogen, and sustainable aviation fuel. And also related to the civil aviation side, we are looking at building MRO facilities in India, because we know Singaporean companies have really done well in that sector. So on that front, this is where the substance of the relationship lies, as well as whereas the political contact is concerned. Somewhere in 2022, there was a realization that we need to expand and deepen our political contact and have regular engagement. So we started with what we call as a India-Singapore Ministerial Roundtable. It's a very unique mechanism we don't have with many countries, nor does Singapore have it with many other countries. We started with total 7 ministers, 4 on the Singapore side and 3 on the Indian side. And we expanded it to 10 ministers last year in 2024. And the third iteration was held in August in India, on 13th of August last week in India. Along with the ministerial roundtable, we also have what we call as a business roundtable, where prominent business leaders from both sides meet regularly and feed into the ministerial roundtable and actually give a feedback as to which areas are working, which areas we need to do more, and what at the political level and the government level people can do and help build that relationship. So we just held the ministerial roundtable on 13th of August, and Prime Minister Lawrence Wong is visiting India next week. So we are also busy preparing for that visit, and hopefully we will have some more outcomes and more work for all of us. At the same time, there has been a discerning trend. We have seen the collaboration expanding at the state level. We've had 6 chief ministers visit Singapore in the last 1 year, and we are seeing Singaporean companies going beyond Delhi, Mumbai, and other traditional cities to states like Assam, Odisha, Rajasthan, and we are encouraging that. At the same time, Singaporean companies themselves have now decided to look at India from a long-term perspective. They are expanding their presence there, both in terms of resources and investments, building up their India offices, and also looking to expand to different parts of India. And of course, they definitely need legal help, and I think this is where the legal fraternity here can contribute. At the same time, the chairman of SEBI was here last 2 days. He had a very good interaction with MAS here. There are, I think, more than 600 FPIs, foreign portfolio investors based in Singapore who invest into India. And so that front also we are trying to expand collaboration and activity. And so this legal field collaboration was long overdue. We have a MOU with the Singaporean side. Our Honorable Law Minister is here. He's going to meet the Singapore Law Minister day after tomorrow, where we have a bilateral mechanism, and we will try and see what more we can get out of that mechanism. So on that note, I will conclude my remarks. I wish this conference all success, and I hope the discussions are fruitful and enriching. Thank you.
Thank you, Dr. Ambule, for sharing 6 pillars of growth and strong collaboration ties between India and Singapore. Great start of the day. Ladies and gentlemen, the Indian legal and arbitration framework continues to evolve under the stewardship of the Ministry of Law and Justice. Indeed, no meaningful conversation on India's legal landscape can proceed without acknowledging the Department of Legal Affairs. It is my privilege to invite Dr. Anju Rathi Rana, Secretary, Department of Legal Affairs, Government of India, to address this august gathering.
Good morning, everyone, all the distinguished guests, dignitaries, and esteemed members of the legal and business fraternity present here today. It's an honor to join here today to address this august gathering on a subject of immense relevance, bridging markets, resolving disputes via ADR in India-Singapore corridor. The presence of luminaries amongst us today, Shri Arjuna Meghwalji, the Honorable Minister of Law and Justice, Government of India, Honorable Mr. Justice A.K. Sikri, International Judge, Singapore International Commercial Court, and former Judge, Supreme Court of India, Honorable Mr. Justice Philip, President of the Singapore International Commercial Court and Judge of the High Court of Singapore, Shri Deepak Ambule, High Commissioner of India to Singapore Government of India, Mr. N.G. Khetan, President ICA, Mr. Arun Chawla, Director General ICA, Ms. Pinky Anand, and Ms. Geeta Luthra, Senior Advocates from India. These luminaries reflects the importance both nations accord to building trust and certainty through deeper legal cooperation and institutional arbitration. India and Singapore share a relationship that is rooted in trust, trade, and tradition. Singapore is not only one of India's largest trading partners in ASEAN, but also a leading source of foreign direct investment to India. Much of this investment is concentrated in capital markets, fintech, real estate, and infrastructure. With such integration comes the inevitability of disputes around investors' rights, valuations, regular compliance, and commercial contracts. If unresolved, these disputes risk undermining investors' confidence. Here is where alternative disputes resolution, particularly arbitration and mediation, plays a decisive role. India's commitment to arbitration is long-standing. In 1927, India was amongst the first 6 Asian nations to sign the Geneva Convention on execution of foreign arbitral awards. Then in 1960, India ratified the New York Convention, becoming one of its 10 original signatories. Ladies and gentlemen, to fast-track commercial dispute resolution, India enacted the Commercial Courts Act in 2015, which enabled the creation of specialized commercial courts at districts and high court levels. Today, over 1,000 commercial courts are operational across India, easing the burden on regular courts and ensuring expeditious resolution. India's arbitration law, the Arbitration and Conciliation Act 1996, is based on unsettled model law. Amendments in 2015, 2019, and 2021 progressively refined the framework, creating the Arbitration Council of India to accredit arbitrators, grade institutions, and promote best practices. Now the draft Arbitration and Conciliation Amendment Bill 2024, currently under deliberation, proposes further improvements such as introducing a 60-day timeline for courts to dispose of application under Section 8 and appeals under Section 37. Second, shifting certain procedural powers like extending award timelines and fee adjustment from courts to arbitral institutions, and reducing regulatory overlapping by limiting the grading function of the ACI. These reforms are designed to reduce judicial backlog and reinforce investor and business confidence in arbitration. But for arbitration to fulfill its full potential, it must be institutionalized. This is where the India International Arbitration Center, IIAC, steps in. A defining moment came in 2019 with the enactment of New Delhi India International Arbitration Center Act, now renamed the India International Arbitration Center. With this legislation, IIAC was established as an autonomous institution of national importance, tasked with providing a credible, structured, and internationally benchmarked platform for arbitration. Under Section 4 of IIAC, the IIAC has been declared as an institution of national importance. This declaration reflects the Government of India to resolve to make India a serious player in the global arbitration landscape at par with major international arbitration institutions. As we gather here today, it is also worth reflecting on the institution at the center of this moment. Back in 1965, when the Indian Council of Arbitration was established by Government of India and Federation of Indian Chambers of Commerce and Industry, few could have imagined just how central arbitration would become to international commerce. Over 6 decades, the ICA has nurtured relationships with more than 50 arbitration centers and industry chambers around the world. So big round of applause for ICA. On its part, Singapore has emerged as a global hub for dispute resolution. The Singapore International Arbitration Center is globally respected for efficiency, neutrality, and credibility. Equally, the Singapore International Mediation Center, coupled with the Singapore Convention on Mediation, has positioned Singapore at the forefront of promoting mediation as a cost-effective relationship preserving alternative to litigation. Making India a hub of international arbitration has been one of the pioneering initiatives of our Honorable Prime Minister, Shri Narendra Modi ji. The establishment of an independent and autonomous regime for institutionalized domestic and international arbitration is central to his vision. In the words of our Honorable PM at the Global Conference on Arbitration, I quote, "Resolution of disputes through arbitration is not new to us. In ancient India, there were several mechanisms for settlement of disputes between the parties. This include the Kulini or a village council, Sreni corporation, and Puga assembly. Likewise, commercial matters were decided by Mahajans and chambers," unquote. He further added, "A robust legal framework backed by a vibrant arbitration culture is essential." This continuity from tradition to modernity underlines India's commitment to making arbitration both accessible and globally respected. By working closely with Singapore, a trusted partner in both trade and legal innovation, we can strengthen the corridor for investment, enhance investors' confidence, and build a dispute resolution ecosystem that serves business across Asia and beyond. As India and Singapore deepen their economic partnership, ADR will remain the linchpin that ensures disputes do not become barriers, but are resolved as bridges. Together, we can set global benchmarks for speed, credibility, and efficiency in dispute resolution. I again congratulate the ICA for organizing this function and inviting us. Thank you. Jai Hind, Jai Bharat.
Thank you, Dr. Rana, for your insightful address. May I now invite Honorable Mr. Justice Philip J. Ratnam to deliver the special address.
Honorable Minister, Shri Arjun Ram Meghwal, Dr. Shilpak Kambule, High Commissioner of India to Singapore, Honorable Justice A.K. Sikri, Dr. Anju Rati Rana, and congratulations in particular to Dr. Kaitan and Mr. Chawla and the whole team at ICA for organizing this important event. I'm delighted to have this opportunity to address such a distinguished gathering of lawyers and arbitrators this morning. And for those of you who've traveled from abroad, a warm welcome to Singapore. And I must say, don't just visit us once. If you've come on your own, well, next time come with your family. Singapore is a very fun destination, particularly for young families. Well, the topic today concerns the resolution of disputes in the India-Singapore corridor. And of course, as the High Commissioner has explained, the connections between India and Singapore run deep and they run broad. India and Singapore are very different nations in terms of size and scale, but we do share many values, including the commitment to the rule of law. Lawyers and judges in both our countries are inspired by the value of doing justice and the importance of remedying injustice. In the area of cross-border commercial disputes, Singapore's relatively small size as a city-state gives us the opportunity to be the neutral venue for many cross-border disputes that have no connection with Singapore, other than the choice of Singapore in the transaction document as the place where they will resolve their disputes. Over the past quarter century in particular, Singapore has become a thriving hub as a provider of dispute resolution services for such cross-border disputes. And this has required us to build institutions, develop skills, and acquire knowledge. It's an entire ecosystem, I think, as Dr. Anju used that word as well, of mutually supporting elements. First, we have a framework of laws that support the various modes of dispute resolution, not just the courts, but also arbitration and mediation. And then we have those courts that fairly administer the law in a way that supports the rest of the ecosystem. An important part of this is speed and efficiency. With the right laws and an effective court system, the stage is set for arbitral and mediation institutions and for the legal and related professions to develop their ADR expertise. A key characteristic is that Singapore is an open, multicultural society. We make every effort to ensure that everyone is welcomed and that we are sensitive to cultural differences. And one obvious manifestation of this is the food. And I think that's possibly the secret to Singapore's success as a dispute resolution hub, because we can get, we will have parties and counsel and experts from all over the world, from different parts of India, and you can find different types of regional Indian food in Singapore, different parts of China, from Korea, from Japan, if you need vegetarian food, vegan food, or if you are from the United States and you need a steak, we have all of those things. Let me now turn briefly to the Singapore International Commercial Court, or SICC. Well, unsurprisingly, you'll learn that given the size and importance of India's economy, the SICC does hear many disputes involving Indian parties. The SICC's structure, its makeup, and its procedures are designed for complex cross-border disputes, and it's important to keep that in mind. Given that such disputes often involve different systems of law, we combine three pillars of judicial expertise: Singapore commercial judges, such as myself, international common law judges, and international civil law judges. Civil law judges from countries like Japan, from Germany, from France, from China. There's great value in combining the experience and expertise of Singapore judges with international judges from leading common law and civil law jurisdictions. At first instance, cases may be heard by a quorum of 3 judges, and in such an instance, the 3 judges would be made up of a Singapore commercial judge, an international common law judge, and an international civil law judge. And each of them brings to the matter their complementary expertise and experience. International judges may sit on appeals as well. On appeal, the international judge will be in a minority. Typically, an appeal will be heard by 2 Singapore judges and 1 international judge. As I've mentioned, our international judges are drawn from many different jurisdictions. What they have in common is deep experience and expertise in commercial law, deep judicial expertise. One of our esteemed international judges is, of course, Justice A.K. Sikri, from whom you have just heard. Who you will hear from in a little while. I think in the program it was the other way around, but you will hear from him shortly. Another way in which the SICC is designed for complex cross-border disputes concerns how foreign law is treated. First, in line with the international character of the court, foreign law does not have to be pleaded and proved as fact in SICC proceedings. Instead, counsel qualified in that foreign law may address the court directly. Judges are able to take judicial notice of foreign law with the assistance of such oral and written submissions from a qualified foreign lawyer. So this is different from the traditional common law practice where foreign law foreign to that jurisdiction, is treated as a matter of fact on which evidence is given by an expert, and then that expert is qualified, and is cross-examined. And that's a somewhat artificial process. Instead, we hear the submissions directly from the foreign lawyers. It's similar to the practice in international arbitration, and then the SICC applies that foreign law to determine the issues in dispute. A third feature is the ability for parties to choose their counsel, even if those counsel are not Singapore qualified. Parties in SICC proceedings may be represented by foreign lawyers registered with the SICC, which allows them to act as counsel in offshore cases, that is, cross-border disputes with no substantial connection to Singapore, other than having chosen the SICC as the court. For completeness, I should note that there are naturally some simple registration requirements for foreign lawyers who are going to address the court. And in this connection, I would note that the number of Indian qualified lawyers who have registered with the SICC has grown, and we have several cases where Indian lawyers have directly addressed the court on matters of Indian law. In addition to its jurisdiction based on parties' express choice, the SICC has jurisdiction over international arbitrations seated in Singapore. In that supervisory role, the SICC strives to deal efficiently with matters coming before us, and we're cognizant that the dispute comes to court for a challenge, whether that challenge is to jurisdiction of the tribunal or for a breach of natural justice. It comes to court after the full-blown dispute has been heard in arbitration, which may have taken a year. So it's important to think about disputes in terms of their entire life cycle, from the moment they start until the time when the case is either dismissed or there is a judgment or award that is then enforced. That's what matters to business. How long does that overall life cycle take? And so it's important for us that in the court we deal with challenges to an arbitration award quickly. At first instance, we typically dispose of those challenges, that is, to the result, within 6 months of filing, and an appeal takes a further 6 months after the appeal is filed. As our name suggests, we are a Singapore court, an integral part of our judicial system. We are a Singapore court that handles international and commercial matters, and the SICC underpins and anchors Singapore's important role as a hub for resolution of commercial cross-border disputes, and in that way, Singapore makes itself useful to the broader world of international commerce, including the trade and commerce that involves India, Indian businesses, Indian parties. With all that, I wish you a fruitful and productive discussion for the rest of the day, and congratulations once again to the ICA.
Thank you, Justice Ratnam, for your enlightening words and deep insights into thriving landscape of arbitration in Singapore. And of course, on a lighter note, no conversation about Singapore would be complete without mentioning the greatest attraction, that is the food. Next, I have the honor of inviting Honorable Mr. Justice A.K. Sikri to deliver the special address.
Good morning, everybody. Our Honorable Law Minister, my very dear friend Philip, Mr. Khaitan, Mr. Chawla, our Law Secretary, our Honorable High Commissioner here, and all the dignitaries sitting off the dais. Let me first congratulate ICA for organizing this symposium, first time in Singapore, and ultimately Mr. Khaitan was influenced by that song that in your life come at least once to Singapore. So in 60 years, after 60 years, although he said that they have been going to various countries, so ICA has also come to Singapore. And let me again congratulate ICA for choosing this topic, if I may say so. This is on bridging markets, resolving disputes via ADR in India-Singapore corridor. As far as bridging markets is concerned, I think a lot is said by our High Commissioner also, and the way Mr. Khaitan mentioned about the greatness of Singapore as well as India, and in his unique style, Mr. Chawla also gave his introductory remarks, and I'm really impressed by what our new Law Secretary said, and I wish her a very, very fruitful tenure also. And coming to, therefore, resolving disputes via ADR in India-Singapore corridor, apart from, in addition to what Justice Philip Jaratne has said, Mr. Khaitan mentioned about somebody stating that India is a dead economy. No doubt, I think one should not bother about those remarks, because rather than in countries, other countries of the world, the person is mocked more in his own country. So therefore, we need not bother about it. But in any case, Mr. Khaitan at the same time gave you figures and facts to show how Indian economy is prospering. But one thing, sorry, which we have been witnessing, the world is witnessing, is that from the era of globalization, which started 60, 70 years ago in full bloom throughout the world, and in last 30, 40 years, it really prospered. It's slowly, if I would say, coming down. And what we have started calling in last few years, that the world is moving from globalization to glocalization. There is a part of bit of globalization and bit of what is happening in local countries, and that is why we talk of, when we talk of India, and every country talks about that, made in India, spirit of India, manufacture in India, and Atma Nirbhar Bharat and all that. So that is localization part of globalization. At the same time, globalization is important because I think the way world has reached today, no country can can live or can prosper without the help of other countries and without mutual cooperation. But what is happening in last few months, I think it has, and the way geopolitics is turning. Yesterday only I read the speech of Singapore Deputy Prime Minister, which he gave day before, and in newspaper I read it yesterday. Very, very, visionary speech, if I may say so, and where the world is heading because of the tariff war which is going throughout the world. But why I'm saying so that in this context, the cooperation, mutual cooperation between two countries, any two countries, is becoming more and more important, and it is gaining more and more significance. And that is where the bridging markets between India and Singapore corridor, that becomes really, really very important. And in this context, resolving disputes, as much is said about bridging markets, I would not say on that. I had thought that I will say something, but let me come to straight away the resolving of the disputes through ADR mechanism and what India and Singapore in cooperation can achieve. Let me tell you frankly, and I think that applies to many Indian persons, particularly from legal community. They are not only in love with Singapore, they are in awe of what Singapore is and what it has achieved. As I have seen in last 15, 20 years of my experience, even when I was a judge and have been doing many cases which came for enforcement, etc., of the awards passed by SIAC in India, and many times the interim orders which we were confronted with even when the SIAC arbitration is going on. The ecosystem which Singapore has developed, and this trinity which I call, is SIAC, Singapore International Arbitration Center, then SIMC, Singapore International Mediation Center, and SICC, Singapore International Commercial Court, which, to which Justice Philip Ratnam alluded to. This takes care of, this is my perception about when I see how they are able to resolve the disputes and how it has become resolving of the disputes in different kinds of disputes in, or choosing a particular type of mechanism internationally. So all are Singapore International Arbitration Center or International Mediation Center or International Commercial Court. And it gives a wide choice. And second thing, the way these institutions today, we know that they are very well known throughout the world. And if I may say so, as far as SIAC is concerned, as I've seen when, 20 years ago, when it was still growing, and the way it has, grown over the years, it was futuristic from very beginning, very, very professionally managed, and those who had expertise in that, and and with very highly professional approach and pool of talented arbitrators, so they could, aided by the government as well as the court. The court, through its various judgments over a period of time, gave that impression, and which impression was created throughout the world, that here is the court which is supportive of arbitration system. Which is why I'm saying so, which is very much required if India has to become an international hub for arbitration. So these are the requisites, these are some of the things which we can take from the Singapore experience and what it has done. Same applies to Singapore International Mediation Center, as I have seen, and again, dealing with international disputes and how you do this mediation. And they are very highly qualified mediators. They have their training programs also, which I know that many Indian lawyers, and we have taken those trainings from the programs organized by SIMC. As far as SICC is concerned, of course, although much is said, but let me tell you the perspective from which I am addressing, that there are many other countries have also come out with the international commercial courts. Now, why these courts were necessary and why it was felt that these are necessary? Because, and there are many kinds of arbitration, many kinds of disputes where parties may not like to go for arbitration. I'm depending on so many factors which I need not say here because of the time limitation at my disposal. But then, and many times, and particularly bilateral investment disputes or investment treaty disputes cases, where many of the ICSID awards and other awards which many countries were not happy with, which we'll be discussing in our panel discussion also in the next round. And this also becomes a reason for taking up the matters to the court instead of arbitration. But these are, again, disputes remain international disputes. But so Singapore came out with this SICC, which was established 10 years ago. And in 10 years, the reputation which is acquired, what I feel is, it is truly international in character. Most of the other countries, except now Dubai and I think Abu Dhabi, have started having judges which are international judges, but this is what Singapore started, and having international judges not only from common law jurisdiction but from civil law jurisdictions as well. And in the combination which they sit and how the benches are constituted, etc., Justice Philip Jairatne has told you. And so therefore, this is how Singapore takes care of the entire legal ecosystem and international disputes. As far as India is concerned, we know ICA is as old as Singapore, 60 years old, and its record is phenomenal success, the kind of, and the trust of Indian businessmen in ICA. There are many institutes in India, but being the oldest and the trust and managed by FICCI, which is the Federation of Indian Chambers of Commerce and Industry, so it acquires very immense goodwill and high reputation, and people have trust in that. But there are, I know, some international arbitrations also they are doing, but it is not as, I mean, India has yet to establish itself as a hub in international disputes. So how we hear some of the takeaways, that is why I mentioned and took some time to tell you about the Singapore, this trinity, or how they manage these things. So in this process, I would say that capacity development and capacity building between Singapore and India at various levels can be a very, very good step. ICA can have its, IIAC has already signed MOU with SEAC, as I know, but ICA can also, I think, have this kind of collaboration and cooperation with the SEAC. So therefore, both of them can come out with various kinds of programs. And one good thing which has taken place in this process is that MOU which was signed between the Singapore Supreme Court and Indian Supreme Court a couple of years ago. And there have been dialogues between the judges of the Singapore and the judges of Indian Supreme Court from time to time. And these dialogues are on various aspects, including on technology, how you have to imbibe technology in the judicial process to decide the cases, which can be at, at the level of ICA and SEAC also. And more importantly, in some of the areas of how international disputes are decided, I tell you, because I have been doing, here I see Justice Ravindra Bhatt, who is sitting here. We are doing Indian domestic arbitrations also, international arbitrations also. But the way the two arbitrations, the manner in which two are conducted, it's really, really very, very different. And we learn to improve our domestic arbitration system by imbibing some of the practices of international arbitrations. And it should not go like suits in the court where tariq pe tariq, date after date after date. It should be in one go, entire arbitration should finish. And in this, I think our lawyers as well as our arbitrators need a good training, which again can be, with the cooperation of the two organizations, it can happen. And as I said, that as far as at judicial level, this is happening, and at judicial level, something more in this MOU, which Justice Sundesh Menon, and at that time when this MOU was signed, Justice Chandrachud was the Chief Justice of India, and they even decided to have this judicial training program for judges. When we come discuss, and we are discussing here about the commercial cases, and here, what kind of cases which come, what are the, because today the disputes are becoming very complex. The issues which are raised are very, very complex again, and it is more so in investment treaties. And therefore, how these are to be decided, how these are to be, what kind of case management conferences should be there for speedy and cost-effective disposal, that both the sides can learn. India, of course, we know 2024, this new this arbitration bill again has been introduced, and I think with this, some of these amendments, when they are brought insofar as arbitration law is concerned, statutory law, it would be, nobody can say perfect, but almost near perfect, and so therefore, ecosystem, statutory flavor we will be having. At the same time, sometimes what happens is that although all these laws, most of the arbitration acts enacted by various countries are based on ancestral law, and which is a model law, but still there are quite differences in approaches, etc. Like if I give you one simple example, which we'll discuss in detail again with Mohit and Lawrence who are sitting here, about the arbitrability of the disputes, that Singapore position is different than Indian position. So how there can be convergence of laws, how we can achieve the uniformity in laws, and particularly in Asia, where I still remember, many of you may not be knowing, Justice Sundesh Menon, I think, started this Asian this law institute more than 10 years ago, and I was introduced as the first person in that. They started that at least there should be convergence of laws, Sale of Goods Act, insolvency laws, commercial laws, etc. within Asia. That attempt is made. We become an active partner in that, and we try to achieve that, so that there may not be much problem in enforcing the awards from one country to other country, because then the questions of public policy of India or public policy of Singapore, those questions may not arise if the laws are similar. So these are some of the suggestions. Yes, I am there in the next session also. I'll speak something more. I don't want to detain you at this further insofar as this inaugural session is concerned. And I wish extend my good wishes to ICA, and I think that it should be a starting of a new and historic chapter between ICA in India and SIAC or SICC, etc. in Singapore. Thank you very much.
Thank you, Justice Sikri, for an insightful address. Your reflections on broader context, including the impact of tariff wars, the importance of mutual cooperation, arbitration in bridging markets, were truly thought-provoking, and they highlight how dispute resolution not only upholds justice but also strengthens cross-border partnerships. Now, I would like to invite the chief guest of the event, Shri Arjun Ram Meghwal ji, Honorable Union Minister for Law and Justice, to share his keynote address.
Very good morning, all of you. A very good symposium organized by ICA. The topic of the conference, Bridging Markets, Resolving Disputes via ADR in the India-Singapore corridor at Singapore. That is the topic, no? Good, sir. This is a very good topic. On this occasion, on the dais, Justice Philip J. Ratnam, Judge, Supreme Court of Singapore, our Justice A.K. Sikri ji, is the International Judge, Singapore International Commercial Court, and former Judge, Supreme Court of India, and the High Commissioner of India to Singapore, Dr. Shilpak Embulem, Dr. Anju Rathi Rana, Secretary Law, the Ministry of Law and Justice in Government of India, President ICA N.G. Ketan Sahab, and Director General ICA Arun Chawla ji, Pinky Anand ji, Alka Chawla ji, Geeta Luthra ji, namaskar, Mohit Saraf ji, Rohit Singhal ji, Kirandeep Singh ji, and Bhumika Indolia. Good morning. One issue has mentioned here, that is the doctrine of based on Panch Parmeshwar. That is Indian doctrine, but I think it may apply in the other part of the world also, because it's based on the nature. In nature we have a 5 element. One is earth, second is air, Pinky ji may correct me. One is earth, second is air, third is water, and fourth is sky, fifth is fire. The composition of the 5 element, I think the 70% is the water, and Singapore is surrounded by the water. So that is why Singapore is important. And that is why the ICA has organized a symposium regarding the exchanging of the best practices of arbitrations, mediation, and conciliations. At the outset, I extend my heartfelt congratulations to Indian Council of Arbitrations for organizing the ICA Symposium that I have already mentioned. This conference has over the years played a pivotal role in advancing the cause of arbitration in India by delivering services that are not only world-class but also efficient and cost-effective. Since its inception, the Council has been instrumental in resolving both domestic and international commercial disputes, while providing all necessary support to ensure the arbitration proceedings are conducted with the utmost efficiency and fairness. These efforts have significantly strengthened trust in arbitration as a credible and reliable means of dispute resolutions both in India and globally. I am informed that the ICA has emerged as one of the most important arbitration centers in the Asia Pacific, handling more than 4,500 domestic and international and maritime arbitrations cases each year. In its pursuit to expand the scope of arbitrations globally, have organized various conferences such as 2 editions of arbitrating Indo-UK commercial disputes at UK and arbitrating Indo-Saudi commercial dispute at Saudi Arabia. It gives me immense satisfaction to be here today at a time when India and Singapore are celebrating 60th anniversary of their relations provides unprecedented strength and vitality. Singapore today stands as India's largest trading partner in ASEAN, with bilateral trade touching US dollar 35.61 billion in 2023 and 24. It has also become the leading sources of foreign direct investment into India, contributing US dollar 14.94 billion in 2024 and 25, and a cumulative US dollar 174 billion since 2000, almost one-fourth of India's total FDI inflows. India and Singapore as partner in ASEAN, the G20 and the East Asia Summit are ideally placed to be equitable partners to each other. Moreover, with the presence of over 7 million Indians, 7 lakhs Indians, and India origins resident in Singapore, representing nearly 18% of Singapore's populations, making the diaspora a direct stakeholder in more reliable, efficient dispute resolutions frameworks. India has risen to be a fast-growing and fourth largest economy of the world, powerful testament to the remarkable growth story charted over the reform, perform and transform measures undertake across the domain. As a region, voice of Global South, India has established as growth partner of the entire Global South. Distinguished guests, here I would also highlight that with more than 9,000 Indian enterprises established in Singapore and over 440 Singaporean companies present in India, the need of the trusted and efficient mechanism of the dispute resolution has grown significantly as both Singapore and India today stand as two arbitrations powerhouses. Singapore has earned a global recognition as a leading hub for arbitration and mediation in the Asia-Pacific region. The Singapore International Arbitration Center reported that the total sum of dispute reached 11.86 US billion in 2024, and notably, India was among SIAC's top foreign users. Meanwhile, India's arbitrations landscape has been significant transformations under the leadership of Honorable Prime Minister Shri Narendra Modi ji, who aims to make India a hub of arbitrations. In recent times, the government of India has taken various legislative initiatives to promote ADR mechanism in the country. Commercial Court Amendment Act 2018, Amendment in Arbitration and Conciliation Act 2015, 2019 and 2021, India International Arbitration Center, Delhi, Mediation Act 2023. Outcome of such measures is that the institutions such as Bombay Center for International Arbitration reported a 48% year-on-year increase in new cases in 2024. Globalization and enhanced cross-border exchanges have resulted in the requirement of the legal ecosystem and the justice delivery to evolve and keep pace with the dynamic requirements. The evolving dispute resolutions mechanism and exciting proactive global cooperation of all stakeholders in this field is very welcoming. India, as a partner of the philosophy of Vasudhaiva Kutumbakam, believes that the whole world is a one family. It is a philosophy that tries to foster an understanding that the whole humanity is one family. In this backdrop, this symposium provides an invaluable platform to foster convergence, promote harmonizations, and encourage joint innovation in dispute resolutions frameworks, thereby strengthening the India-Singapore corridor of cooperations. Distinguished delegates, India is steadily moving towards the goal of Viksit Bharat at 2047. A central pillar of this vision is the creation of a business-friendly environment supported by a dispute resolution system that is quick, reliable, and cost-effective. To realize this, a series of important measures to strengthen contract enforcement and improve mechanism for commercial dispute resolutions, thereby making it easier to do business and instilling greater confidence among investors. Recognize both present needs and further challenges, significant reforms have been introduced in the field of alternative dispute resolutions with the aim of positioning India as a global hub for arbitrations. In conclusion, the significant reform in India's arbitrations laws and establishment of India International Arbitration Center mark a decisive step towards creating a world-class dispute resolutions framework. These initiatives ensure that the arbitration in India is faster, more efficient, and more trustworthy, qualities that are essential for a thriving business ecosystem. This progress strengthens contract enforcement and builds greater confidence among both domestic and international investors. A modern and effective arbitration regime lies at the heart of visions that provide investors a sense of certainty, neutrality, and efficiencies while reducing cost and risk in cross-border disputes. While growing collaborations between India and Singapore in capital markets, FDI, fintech, and digital trade, credible and timely dispute resolution will play a central role in sustaining growth and deepening investor trust. This symposium is therefore not just a dialogue, but a platform for greater institutional and judicial cooperation between two nations. It offers an opportunity to deliberate on issues such as arbitrability of FDI and capital market disputes, and balance between investor protection and regulatory oversight, and the possibility of joint protocol or arbitrations panels to resolve India-Singapore disputes. By working together, India and Singapore, two dynamic democracies with rapidly growing economies, can set global benchmark in fair, transparent, and efficient dispute resolutions, reinforcing our shared commitment to prosperity, stability, and sustainable development. Jai Hind.
Thank you, Shri Meghwalji, for your visionary address and for bringing alive the wisdom of Panch Parameshwar. Your example of Singapore importance stemming from being surrounded by water beautifully blends age-old philosophy with the modern world we live in. As we draw the opening session to a close, I once again invite Mr. Arun Chawla ji to deliver the closing remarks.
What a thought-provoking and inspiring address by Shri Meghwalji, Honorable Union Minister for Law and Justice. Sir, you have conveyed what India stands for and where are we heading in our dispute resolution regime. Ladies and gentlemen, as we conclude this opening session, I also wish to extend my highest appreciation to other dignitaries on the dais, Dr. Anju Rathi Rana, Honorable Justice A.K. Sikri, Honorable Justice Philip J. Ratnam, and Dr. Shilpak Ambule for their enlightening addresses. Collectively, ladies and gentlemen, their reflections have reaffirmed a fundamental truth. Alternate dispute resolution is no longer an alternative. It is a necessity. It is the foundation upon which investor confidence, regulatory trust, and cross-border cooperation must be built. Ladies and gentlemen, every speaker on the dais has enlightened us on so many contours of India-Singapore corridor. So once again, join me in giving them a thumping applause. The India-Singapore partnership offers a powerful model of how economies can collaborate, not only in trade and investment, but also in shaping dispute resolution systems that are fair and efficient and globally respected. Investor sentiment across Asia today depends not only on economic returns, but also on the jurisdictions that provide legal certainty, institutional resilience, and commercial pragmatism. Singapore has become a safe harbor for capital, while India is steadily asserting its role as a reform-oriented economy with growing global influence. The recently concluded third India-Singapore Ministerial Roundtable is a clear testament to this momentum, with agreements spanning connectivity, digitalization, healthcare, skills development, and advanced technologies. Our High Commissioner has enlightened us on all those things. These developments underline that commerce and dispute resolution are inseparable twins. One cannot thrive sustainably without the efficiency and integrity of the other. Ladies and gentlemen, at this juncture, I would like to recognize the presence of Honorable Justice Ravindra Bhatt, former Supreme Court Judge of the Supreme Court of India, and an eminent arbitrator now. Please welcome him. As we now move to the roundtable discussion, we will delve deeper into the critical themes, including arbitrability of FDI and capital market issues, the role of regulators and courts, investor protection, and institutional collaboration between India and Singapore. On behalf of ICA, I once again welcome all the delegates and urge them to actively contribute to the deliberations of the Roundtable and join us in shaping robust, future-ready institutions of cross-border commerce. Thank you.
Thank you all once again for your presence and participation. We will now have a short 10-minute break, and thereafter we move towards roundtable discussion. I request all the dignitaries to please gather for a picture. I request roundtable discussion speakers to please join us on stage for a picture with the dignitaries. I request the speakers for the roundtable discussion to please join us on stage for a picture with the dignitaries. And also, Alka ma'am, please join us on stage. Justice Ravindran Bhatt, request you to please join us on stage for a picture. We will now have a short 10-minute break and request you to please join us for a roundtable discussion within 10 minutes. discussion. And I request all of you to please be seated. We are about to begin the roundtable discussion. Yes, yes. So then you're going to hand it to him. You want him to come here? No, no, the mics. You will get?
No, you can, but I'm going to sit down. I'm not going to come.
Yeah, panelists will be speaking. Yes, 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 yes. We are now... We are now ready to begin the roundtable discussion, and I request all of you to please be seated. The roundtable discussion will guide us through the nuances of alternate dispute resolution in effectively resolving disputes and bridging markets across India-Singapore economic corridor. It is my privilege to introduce the chair of this session, Honorable Mr. Justice A.K. Sikri, International Judge, Singapore International Commercial Court, former Judge, Supreme Court of India. He is known for landmark rulings in commercial matters, tax, and IP law. He leads several key legal and policy bodies in India. Joining Justice Sikri as moderator, we have Mr. Mohit Saraf, founding and managing partner, Saraf and Partners, alongside Mr. Francis Xavier, SC Regional Head of Disputes Group, Raja and Tan, Singapore LLP, and member of ICA International Advisory Board. Mr. Saraf is distinguished leader in the legal fraternity, serving as a member of both Steering Committee and the National Executive Committee of the Federation of Indian Chamber of Commerce and Industry. Mr. Francis has over 36 years of experience in cross-border commercial litigation and the international arbitration. Furthermore, for this session is an esteemed panel of legal experts who bring them a wealth of experience and insight. Dr. Pinky Anand, Senior Advocate and former Additional Solicitor General of India. Dr. Anand is an internationally acclaimed arbitrator, a published author, and a distinguished authority in the field of private international law. Ms. Geeta Luthra, Senior Advocate at the Supreme Court of India and the Delhi High Court. Ms. Luthra is an accomplished arbitrator, having handled several high-stakes domestic and international arbitration matters. Mr. Rohit Singhal is a CEO of the Mason Group. He brings over 26 years of international consulting experience in project management, construction disputes, and expert testimony. Mr. Shao Shan Yu is a managing partner, head litigation, dispute resolution groups at Wong Partnership. Mr. Yu specializes in banking, trade finance disputes, insolvency, corporate fraud, regulatory matters, and both domestic and international arbitration. Mr. Kirindip Singh is a senior partner, litigation, dispute resolution, and arbitration practice groups at Dentons Rodkis, Singapore. Mr. Kirin co-heads the construction, international trade, and energy practices and focuses on arbitration, construction, energy, commercial litigation, etc. I request Justice Sikri to give an opening remark to begin with the session.
good afternoon to all of you. I think we are already running late, and there's such a celebrated and esteemed panel with the two very, very experienced moderators and other very accomplished speakers. So therefore, I would not say much in the opening remarks. In between, if I have to say, or at the end, I'll see. But going by the concept paper which was circulated and which by the ICA, and which contained some of the aspects, and I hope that these are going to be discussed from the questions which were shared. I would only make 2 or 3 remarks because I have said something which I will not repeat that as well, but that is also going to be discussed about how the cooperation can be there between India and Singapore on these aspects. One is about the arbitrability of cross-border commercial and investment disputes. Actually, it's a very interesting, and as I had mentioned earlier also, and I think this is one area where in spite of India, Singapore having their arbitration acts which are on the model of UNCITRAL, and in spite of common law jurisdiction and almost similar provisions, but still on the arbitrability of cross-border commercial disputes, there's a difference in approach, particularly the way Indian court decided and the way Singapore courts are deciding. It's going to be a really, I hope, an interesting discussion on this aspect and how there could be and how we can enhance convergence in this. And Singapore, if I may say so in only preliminary remarks, in recent judgment in Anupam Mittal case, Singapore Court of Appeal has held that arbitrability is governed first, these are two, by the law of arbitration agreement, and secondarily by the law of the seat. So therefore, if the law of this arbitration agreement mentions about the arbitrability, they will go by that. And in case, but it is law of seat which would be the governing law. In contrast, in India, actually the law which is applied is that we say that, okay, it is the Indian law which will apply, irrespective of whatever is stated in the agreement. And if some of the disputes are non-arbitrable as per our Indian law, then they cannot be arbitrated and they are accepted matters. And from Booz Allen and all those cases which have been decided, and particularly the cases like insolvency matters, family law matters, and where some public functions, etc. are there. There were criminal matters, I remember, on this fraud, whether that can be, it was excluded in Booz Allen. And then we gave one of the judgments in Ayaswamy case, I think, with me and Justice Dhananjay Chandrachud, we authored, that said that not that wherever there is an allegation of fraud. So much is simplified thereafter, but still, these are some of the areas. And the only one more area on which I will give my remarks in the initially would be about the investment disputes. Actually, as far as investment disputes are concerned, as we know, I mean, these are really much challenge is thrown. And in India, we have some experience of some of the awards which Indian government suffered, particularly white industries, which was very, very, very much criticized even by Justice Sunderesh Menon in his article written way back in 2014. He had written a remarkable article. Justice Sunderesh Menon in that article highlighted, and what is going to be the discussion, that on the one hand, yes, we know that the arbitrators, the investors, when they invest in other country, foreign investor, they have to have their investment secured with the proper returns also they would need. On the other hand, So therefore, we have the clauses of fair and equitable treatment and FMN, this clause, etc., in the investment treaties. And the law against expropriation, that no action can be taken by the state which would expropriate the investment. And if all these things are done, then the matter can be brought before the arbitrators on that basis against the state for claiming that. But this comes many times in conflict with the sovereign function of the state or the sovereign powers of the state. And in that article which I was referring to, in respect of the 3 cases I still remember he discussed, one was relating to Bangladesh, one was this, and one was USA. And in all these cases, without going into the details of these cases, in all these cases, what he mentioned was that, look, in 2 cases, ICSID, in 1 case, PCA, Permanent Court of Arbitration, what they have decided as if they are even superior to the national courts. The judgments of the courts were given contrary to those judgments they had decided, ignoring. So whether, the judicial function is also a sovereign function, and if a particular, in the state court or in the host nation court, some dispute is decided, those courts can go on the basis of this FMN clause which was invoked in White Industries case, where of course the case was still pending as well as the earlier dispute settled by the commercial arbitration was concerned, still pending, but the challenge was pending. And he said that what would have happened if this had been set aside. The occasion did not arise because Indian government accepted the award and finished the matter. But what it resulted ultimately in the this cancellation of all these treaties. India cancelled, and so they have come out with the new treaty in which the dialogue is going on between India and Singapore also. They are bilateral treaty, and I think you will try to discuss and how we can draw a balance between the state sovereign power on the one hand and the investors' rights on the other hand. So these, and there are some of the, I think you are going to discuss about the, in any case, collaborative mechanism, etc., on which I had made certain comments earlier. I would not say more, and I think let us hand it over to the 2 moderators here to take the session forward. Thank you very much.
I think, let me just pick a remark which Justice Sikri said. He really mentioned a lot about sovereign function. And I always wonder, I said, entering into contract clearly between 2 parties is not a sovereign function. And a dispute between 2 contract parties, whether it goes to the court or it goes to the arbitration, is not a sovereign function. And I think Justice Sikri understands that, and Justice Bhatt understands that. But I think what is important on Indian arbitration circle is to understand that this dispute is a commercial function, and all of us in the room are the service provider. Because I think that once we understand that, I think we'll get quick enforcement, quick dates, good adjudication of dispute at the arbitration level, and a lot of Indian dispute would get settled in India through arbitration and mediation. But let me start, because the topic of the discussion, and because Justice Sikri, you mentioned this topic of sovereign, I said, okay, let me pick up something and express my view. Particularly if we are talking about India and Singapore as a corridor. And maybe just the minister mentioned, and I want to give you a little facts and figures. So we understand it is an important corridor, but why it will be very important going forward. And therefore, there is a great opportunity for all of us to support. Also, there is a great opportunity we may not be able to use it properly, and an opportunity will be missed. So I thought I'll bring that aspect here, and then we will get into the mediation and arbitration bit. Particularly if most of you may not appreciate that Singapore actually is the largest FDI investment in India, largest for 7 years. It's almost to 30%. Large part of investments come from Singapore companies, be it Temasek, be it GIC, be it Semcorp, be it Singtel. Also, equally large portion comes from global corporations which have Singapore as a hub. The General Counsel sits here, the Chief Officer of the Asia Pacific sits here, and they do that. So therefore, whether it's money, whether it's technology, whether it's license, whether it's expertise, there's a huge flow of capital, expertise, and technology between India and Singapore. I just wanted to make sure that we understand this corridor and the importance of this corridor going forward. Let me give you again a little bit, because problem with me is I'm a maths graduate, and then I became a lawyer, so I have to give you a little numbers, because numbers tells you the story. I think today as a country, we are $4 trillion, and it took a long time to get here. We took 75 years to reach $4 trillion with a lot of people. So per capita is very low, but as cumulatively, we are a large number. But what is more important is, when you are, as a country, when you get to a $4 trillion, when you get a purchasing power parity, what Indians generally has, that is where the growth accelerates. I think that's an important part where the minister also talked about that the growth is accelerating. And this is an important part to understand, that whatever numbers you talk, S&P upgrades, we heard about it, but whatever you talk, next 10 years, we will be at $10 trillion, okay? Whatever, we can mess it up. India, we can obviously always do that. We are expert in that. But even if we do that, we can take from 10 to 12 years, but we can't miss the boat. But what is important, and this is a very important part for all of our providers here, is that when you move from a $4 trillion to $10 trillion, you're adding $6 trillion. As per the World Bank, you need to invest 50 cents to add $1 of GDP. So therefore, in next 10 years, there's going to be investment of $3 trillion into India. You can imagine the level of shareholders dispute. You can imagine the amount of construction disputes. You can imagine what it will go through. And that is a very, very important part for us to understand the opportunity. The other part, if you look at the formal dispute resolution in India, and this is again a very important facts and figure. In Singapore, it takes 150 days for a dispute to get resolved at the first instance, not at the appellate court, but at the first. In India, it takes 1,445 days, almost 4 years. So therefore, formal system may not work that much because our courts are overloaded. We can go for interim relief, we can go for enforcement of award, but largely it is this ADR where the opportunity is. So right now, I think the court systems, you can go there, but really the focus is on ADR. And that's the reason the topic, as the minister said, is very relevant for next 10 years, when the growth accelerates into India. And therefore, and more important, I think the first part, because in 2023, India enacted mediation law, and it is approved, and therefore we start a discussion on the mediation law, and then we'll move to arbitration. So Pinky ji, let me start with you. She actually was my first guru. And in this dais, we have two Guru Mahas for me. And I was told that you can't call them Guru Mahas, but I'll still call, because Pinky ji and Geeta, I started my initial litigation practice with them, and then I left and ran away and became a corporate lawyer. And now I've come back again. But let me ask Pinky ji your question. How transformative do you believe the Indian Mediation Act is? And what limitations do you see in implementation?
Mohit, thanks. I think Mediation Act has been a very important component of what we've been wanting to do for a long time. ADR came into being as a holistic formula. It wasn't arbitration alone. It was meant to encompass mediation, conciliation, and all these elements. So I think Mediation Act has heralded a structural transformation, and believe me, it's really been implemented in a big way. Recently, about a month back, we had this huge conference in Delhi, and where we had representation across all the courts all the prosecutor generals, the advocate generals, and ultimately the process was that we don't really want to litigate or arbitrate also at the first instance. If it is possible, a commercial dispute definitely has all its consonance with mediating and finishing of a dispute. So I think the structural formation of the Mediation Act, and in fact the process is well on. Aside from the Act having come into being, the rules have to come into being, and in fact the appointment of the tribunal, which is one of the major accreditation. There are various people here. Varna here is a trainer in mediation, and now trainers are training trainers. This whole process is actually gallivanting onto its own territory. But having said that, I mean, any dispute, as I said, in short, which is mediated or conciliated and results in a binding, because we have a binding decree now. If a mediation is done, it is effective, it can be implemented and enforced as a decree. The problem areas, let's come to that for a moment. International mediations are not so far binding. So you really have to go to local courts for implementation, and I think that is something that we need to work on. While we are talking here in front of people like Justice Sikri and Justice Ratnam, and we are talking about international and localization, as we call it, we really have to ensure that that process is well on its way, and we need to put it there. The contradiction, for example, is that a conciliation agreement is executable and enforceable under the Arbitration Act. But we don't have an international mediation, and today, as I said, the global world, the local world, we just have to put that into operation. So one of the serious infirmities that we've left, and this is despite the fact we are signatory to the Singapore Convention. We have signed it, but we haven't implemented this part. Singapore is. Singapore, of course, you have international mediation, which is enforceable. So I think these are some of the areas that we can pick up and conclude so that we can take this conference in a big way and the symposium further.
So just to make sure, because I've always been an associate for Pinky Ji, so just clarify the senior advocates thing. When she mentioned international, she basically mentioned foreign seated. But if it is domestic international, it is covered under the Indian Mediation Act. And that's an important part. Good. Geeta Ji, let me ask you that question. That do you see in complex commercial issues, complex issues, multiple parties, a lot of give and take can be done. Do you see people moving toward mediation?
I don't think I see them moving, not just mediation, perhaps arbitration, mediation, arbitration, the hybrid could be possible. And that is something more palatable for people. So if you go straight for mediation, for example, I would be a great proponent for pre-lit mediation. But pre-lit mediation on its own, without the Commercial Courts Act, pre-lit mediation has been 95 to 97%. The success rate has been a failure. So we then have to look at the Commercial Courts Act and how the courts are looking at it. And one is happy that the Supreme Court and the courts are actually dismissing petitions on Order 7, Rule 11, saying no cause of action, premature, and therefore not entertaining them without mediation. But to my own reasoning, if it's arbitration coupled with mediation, going back to arbitration, with this, who should be the mediator is a question mark. Should it be the same hat? Should it be a different hat? To my mind, it should be a slight different hat. It should be. But having said that, because of confidentiality, because of various things, but I believe that in complex commercial matters, there can be even arbitration. There was litigation fatigue. There can be arbitration fatigue also. And therefore, I think it's perhaps what will be more successful as we go on.
I think very good point. I think what is important for all of us to understand, the Mediation Act by itself is almost reasonably on the same platform as an Arbitration Act. You can get interim measures, it's like a court degree. So there's a lot of good things. But I think what bothers me, and I want to come to Rohit and ask that question, but before that, I'll tell you my botheration. India right now on enforceability of contract is bottom 25 in the global ranking. Now, a mediation only works when there is a danda of a court or a danda of an arbitrator, an award. Mediation by process has to be consensus. You have to agree to the terms. So I don't know, in typical countries where the enforceability takes a long time, typically parties get divided into two types. One is rightly enforcing right. The other is trying to delay it, because if the enforcement happens, they have to pay off. And therefore, mediation to that extent becomes a challenge, because you have to agree, because there's no danda at the end. And therefore, I go to you, Rohit, because the government removed on large contracts, which you work quite extensively, on large contract that says, and it's not large, like $1 million plus contract, are small contracts actually, if you look at $4 trillion GDP. So it's small contracts of $1 million plus. They said now arbitration should not be a dispute resolution mechanism, mediation would be, and otherwise go to the courts. And there is a government notification to that extent, and there are advisory from the, so tell us about that. Are you seeing, particularly after the finance ministry came with the notification, are you seeing a little bit different thought process, both as a part of incorporating the mediation terms and the way the government, because typically in all contracts, in infrastructure contract, government or government agency is one of the party. Give us your perspective, please.
Yeah. Thank you, Mohit. So Mohit, you rightly said that the presence of that danda, the stick, is right now not there. And as Geeta ji also said, whether mediation is going to be the right dispute resolution mechanism is still a big question mark. The industry, if I see, is extremely concerned. And if I go by numbers, infrastructure, construction industry, and the construction industry associated disputes in India are it's the third largest construction dispute market in the world. Construction and infrastructure contribute almost 10% of India's GDP. And there are massive number of court cases which are lingering in India for enforcement and challenges in arbitration. Now, till 2015, things were pretty bad. After 2015, once the amendment came into the Arbitration Act, things improved. And from 2015 till 2025, the contracts of construction had the arbitration as the dispute resolution mechanism. And if people who practice construction law knows that typically an infrastructure project or a construction project has got phased resolution of disputes, which means that first the parties are trying to discuss the dispute, then they have the dispute adjudication boards, and then you have the arbitration, and then of course you have the enforcement and challenges of the arbitration award. Now, fortunately, as on date, when we see the construction contracts, because these are contracts which were probably floated some 3-4 years back, still mediation has not come into forefront in these construction projects and in construction-related dispute resolution. But now, the new tenders which are coming in, the government has come out based on this notification of the Ministry of Finance to limit arbitration for disputes up to $1 million, 10 crore rupees, and anything above that, many of the tenders are now saying go for mediation. Now, coming from the industry, the construction industry is reeling and is an industry which primarily works heavily on cash flow. Now, once you have a dispute, and typically, if a project is of $1 billion or $500 million, generally, 20-25% of that value is entangled into dispute. Typically, if I work on numbers, the profit margins, the EBITDA margins of a typical construction contractor would not be more than 2-3% or so. Now imagine you have such a huge value which is lingering in dispute, which includes performance bank guarantees of 10%, liquidated damages, delayed damages of another 10%. So you have such high value, the industry and specifically the private parties are looking for a faster resolution. And if you see, lot of mediation has already taken place, maybe not the formal mediation as per the Mediation Act, but a lot of mediation has already taken place between the parties, and when things have failed, the next move is done to the arbitration. So the private contractors, the private parties, the supply chain are extremely concerned whether the mediation system is just another way of prolonging the resolution, getting the hard cash into the bank accounts, or is it going to be a process which is going to be helpful for expediting the inflow of money, for helping the companies to, in their cash flow and all. And as you rightly said, you're talking of additional $6 trillion worth of GDP growth in next few years, and out of which almost 30-40% will be coming from construction and infrastructure. And India definitely, as we all know, requires a lot of infrastructure. So until and unless we do not support a faster and a quick dispute resolution, the companies who will be investing money would not be able to support the required infrastructure growth. So to, in nutshell, the industry right now is a bit bothered, bit concerned, and you and Madam Geeta very rightly said, maybe mediation could be one right possibility where once the parties are in arbitration, they see the real facts of the case, then they go and try to settle through mediation. If not, then go back to arbitration. But a mediation alone, and right now the Ministry of Finance directive is making the private parties and even the government as concerned whether this is the right step.
Because I think what is important is that in enforceability is a challenge, mediation does not work. And mediation can only work when both parties have very strong case, and the only issue is the interpretation. Then the mediation can work. But really, at what is important is that if you look at the Indian environment, I think particularly a lot of our clients who are sophisticated clients who have been building high-quality infrastructure projects, they say, now we can't participate. There's no way we can run because in construction companies, you have a lot of change order issues, specs changing, everything changes all the time. And therefore, if you don't have an arbitration process as something which can resolve the dispute in a quicker way, it doesn't work. And you're absolutely right. Most of them, if you remember, the earlier phase, post-Lehman crisis, India went through a crisis where all banks almost collapsed and all infrastructure companies collapsed. So this is the second time we can get there if people bid and they get into mediation. So this is a very important thing, particularly from everybody's perspective, to take it to the government, that this is an important change which we need to bring. Whatever is, I think, the problem, if you look at some of the judgment in India where the domestic arbitration award has been opened up by Supreme Court in various things, what requires is building more accountability. What is required is building more institutions and making sure that ICA gets all the matters and they run it strongly, and that is more important. And maybe what is also important is, particularly with a government-related arbitration, government is one party. Maybe what is required is maybe the arbitration pleadings and award should be published to build accountability. But bringing mediation instead of arbitration, I think is a very backward step. And I think the government should think about it. So Sean, let me ask you one question. Particularly, I think the mediation enforceability is 155 days here. So you are pretty much there. So you know after 155 days, the court will award damages if you are a wrong party, and in Singapore. So therefore, the mediation perfectly should be working in this country. Give us your thought process, because now you recognize even foreign settlements, right?
Firstly, a very good afternoon. I just want to say that it's a real privilege and honor to be able to be part of this roundtable and seeing some old friends in the audience as well. Mediation is it's all relative, right? When I first started practice almost 30 years ago, it was very much in its infancy in Singapore. It kind of like picked up speed in the early 2000s when our Singapore courts recognized that it was a very important component of the court ecosystem. And so there was a procedure where midstream certain cases would be identified for mediation, more than strongly encouraged to refer to mediation. And so the success rate from some of those settlements were obviously very encouraging because it served to be a filter, for those cases which really shouldn't go to trial. And I will say that in my firm, mediation advocacy has now become very important. So it's not just litigation advocacy, but our young lawyers are exposed to training sessions on how to attend and do advocacy and mediation sessions because it's as I said very much part of our toolkit today. Singapore's progress obviously has gone on with the Singapore Mediation Convention, and we've taken the lead in making sure that the necessary legislation was, in fact, the legislation was drafted even before the convention was, formally signed by all the signatories, and came into effect the very same day when the convention was signed in Singapore, almost 5 years ago. So we now basically have legislation which provides for the enforcement of international mediation settlement. We, in fact, had a Mediation Act enacted in 2017, which provided for a procedure where mediation settlements can be recorded as an order of court so that you can then have the enforcement process. There are also mechanisms in the Mediation Act which provides for a stay, pending mediation, and basically a procedure which provided for a support of mediation. And I obviously, we've always had a MET protocol which the SIAC developed with the Singapore International Mediation Center, which just celebrated, I think, its 11th anniversary this year. So all of these things have helped make mediation a very important component of the dispute resolution landscape. And I think it's worked well for us, but bear in mind, it took us some years to get to where we are. And so I think that journey obviously will need some time and would require, a certain, I suppose, change in mindset as to how one encounters mediation. But that's basically been the Singapore experience, and I think it's been quite successful.
So I think now the next session will be taken over by Francis Xavier. I don't think anybody needs his introduction, but let me tell you another side of him which I saw yesterday. We had dinner last evening, and Amit from ICA, who was really looking after all of us, I think I've never seen somebody like him really pay so much of attention to make sure that Amit gets his food. So I think it requires a big round of applause.
Thank you, Mohit, you're being too kind. Now, I'll just make 2 points. First of all, we are very grateful that all of you are still here in full force, despite the serious overrun. And right now, we are supposed to be having lunch. I know I'm reliably informed it's perhaps 20 minutes past 10 in Delhi, but we do apologize in particular to the Singapore crowd. Do bear with us a while longer. The second point I wanted to make was Judge Sikri very rightly pointed out, the state of the investment dispute scenario. Unfortunately, I think as between Mohit and I, in the limited time that we had not arrowed the panelists. We were not planning to arrow the panelists with any investment type dispute questions. But I think Judge Sikri, there are 2 panels. In fact, its Secretary General Martina Polensky and a team are down. We're having a session at 5 today, actually dealing with that backlash issue. And there's one by ICL.
I saw the concept paper and from there.
Right. Fair enough. And the ICLRC is having another session at 2 tomorrow. But just the experience, just so that Judge Sikri, we answer it. I think we all know that post 2014, after the MFN White Industries outcome, the Indian government had cancelled, I think, about 75 BITs, predating 2014. And to date, I believe there are only 9 BITs in effect with India in force, and only 4 of them, one of them was 2014 and 3 were post-2014 that India had entered into. It issued the 2016 model BIT, which, I think the concern was firstly that private interests were being magnified in ISDS processes and public interests were being marginalized. State ability, as Judge Sikri pointed out, to regulate state health concerns internal environmental protection concerns in the Philip Morris case, for instance, safety and health, were being compromised. And so the model BIT, India's 2016 model BIT, severely curtailed investor rights and enlarged regulatory freedom of states to regulate in these critical concerns. And I think that's been played out not only in India, all across Asia, Indonesia, and even in South America. And I think that the learning there has been that previously, I think states were very content to pick up standard treaty provisions and just enter into treaties. But now they're being very, very careful. Definition of investors, as carve-outs, when, investors will not be able to bring a case, right, for important carve-outs in environmental, taxation, health and safety. And that's what we've seen. And the debate is still raging. RCEP, ASEAN RCEP framework, we still don't have an ISDS provision. We're still debating whether ISDS provisions should be incorporated, even though the treaty has been entered into. But I will now, with that, switch back. Rohit, I don't want to increase Mohit's botheration levels, but if I could ask you this, and I think we have not allowed entry into of any reporters, so we can be frank here. But Rohit, what has your experience been in India-seated arbitrations? Do you think they've served your clients well, especially in the infrastructure arena where you've been very involved in? And do you think further reforms and tweaks needs to be introduced, Rohit?
Thank you, Xavier. So I think Indian arbitration, domestic India-seated arbitration, things have really improved quite drastically. There was a time before 2015 when there was a saying in construction industry in India that the grandfather will start the arbitration and grandson will probably get the money. But things have changed very much. They have changed. And now you see India-seated arbitration where, it's as efficient, if not completely 100%, but very close to 100% as you see any international arbitration. I practice as expert both outside India, international arbitration, as well as in India. So I see things have drastically improved. Yes, always there is a room for improvement. Like now, there is a time limit within which you can get the award. Of course, after you have the award, the enforceability and challenge continues to be one of the major concerns because ultimately, you need money. But despite that, there are provisions where you can get 75% of the value of the award. Many of the public sector undertakings and government agencies have come out with the provisions that even when you have a kind of a dispute adjudication award, they are ready to pay 75%, which is helpful for the construction industry, which, as I said, primarily works on the cash flow model. And role of experts, because construction or infrastructure is an area which is technically complex. You have technical issues, changes in the specifications, delays, etc. So there was a time when experts were not, entertained much in the domestic Indian-seated arbitrations, but now you see that experts are being called in. In fact, Justice Sikri also is quite instrumental in even appointing tribunal-appointed experts and all, which is, helping the tribunal to understand. Which is, thank you, sir, thank you for that, which is unraveling the technical issues. So things have improved, at some stage, you would have typical, writing of the questions and answers coming in. Now transcription services have come in, which is efficiently, reducing the time of and cost as well. Earlier, a lot of dates were happening, a lot of challenge, keep on having multiple dates for hearings and all. They have also curtailed down. You have hearings coming out in one single shot. So I think things have really improved. And also for a change, many foreign practitioners of arbitration, etc., have started coming in as arbitrators. So things have improved. Of course, more changes are going to be there. They are being brought in. But I would say we are on the bright side of the.
Thank you, Rohit. On that note, I wanted to. Mohit reminds me we have hitherto ignored Kirindip. So Kirindip, tell us, what do you see from outside India perspective? what gives you confidence in the recent reforms and beyond that India is a good seat for arbitration?
Francis, thanks for clarifying. The press is not here because I'm from Singapore. I'm supposed to be promoting Singapore, right? So you're asking me about India as a preferred seat. So I have from the outside looking in to try and promote India as an arbitral seat. Actually, there are a lot of positives with India, and I've been going to India for many years. And India has really improved leaps and bounds when it comes to arbitration. I mean, the first reason why we can have confidence in India as an arbitral seat is the increasing judicial support for arbitration. And that is coming out from a lot of cases. I think recently, I think you have before you a very small pamphlet which has been very well written, and it talks about India improving in arbitration. And there were some cases there which I actually spotted myself that are very interesting. You have the De Soto Merrill Life case, where the Indian courts actually followed international standards in the sense that when it came to an arbitration agreement that didn't specify the governing law for the arbitration agreement, the Indian courts had reference to the Seoul America case. And there they said that, well, we would give in to parties' intentions, especially the governing law of the contract. You have also the Tomorrow Sales case, where the Indian courts clarified the boundaries of third-party funding. And they clarified the fact that third-party funders cannot be held liable for adverse cost orders, third-party funders cannot be held liable for satisfying the arbitral award. So they recognize these global trends, these global developments. Third-party funding is quite entrenched now in international arbitration, and the Indian courts are actually keeping up pace with that. I think Justice Sikri mentioned fraud and arbitrability. There's this Indian decision of Avital and HSBC, where there was a question about fraudulent misrepresentation, and there was an attempt to set aside the award, the Singapore-seated arbitration, on the basis of public policy and bias. But the Indian courts upheld the award. And what the Indian court said is that, well, since fraudulent misrepresentation is arbitrable under Singapore law, Indian courts would not interfere with that. So these are very encouraging developments that increases India's prominence as an arbitral seat. The second point is, well, your legislative reforms. Some people say they are knee-jerk reactions. I say no. India is being very nimble and adapting itself to the global trends or global demands when it comes to international arbitration. So you've had amendments in 2015, 2019, 2021 to your Arbitration and Conciliation Act. You have reduced the public policy grounds, ability to challenge on public policy grounds. You have brought in expedited arbitration, right? So all of this gives confidence to the international community that India is keeping pace with global international arbitration. Third point, I think that puts India in a good position is emergence of institutional arbitration, right? You now have MCIA, you have the Delhi International Arbitration Center, you have the Nani Pakiwala Arbitration Center. That's right, correct.
I was saying where we are.
That's right. So, and you've got ICA, and ICA, I mean, I've taught on ICA courses for a lot of practitioners and industry people, and you're bringing in training courses and all that. And of course, SIAC and ICC also have panels of arbitrators in India as well, and which you can tap on. Of course, India is a signatory to the New York Convention, and now patent illegality is something that can only be challenged when you can only utilize when it comes to domestic awards. And of course, as I mentioned earlier, violation of public policy under Section 34 is also quite narrowly interpreted. So it gives confidence that international arbitration awards will be enforced in India, and that puts India in a good position as an international arbitration seat. Finally, or no, second last point is that, well, Indians are English-speaking, common law background, and many prominent Indian practitioners and former judges are on ICC panels, SIAC panels, right, LCIA panels. So that puts the Indian profession, the Indian legal profession, in a very good standing in the international arbitration community. And finally, you're adapting to virtual hearings. That's becoming something quite common, and your institutional arbitral institutions in India are having expedited hearings, are having virtual hearings. They're signing up to these technological advances. And last but not least, something that Justice Philip Ratnam mentioned as to the reason why Singapore is a preferred seat of arbitration. India can say the same. You have very good food, right? So a lot of international players would like to come to India because that would be taken care of as well.
Thank
So
you.
that's all, Francis.
So the
yeah.
positives are endless because he said finally twice, and beyond that there was a last point.
Oh yeah, sorry, yeah.
But
yeah.
that's okay.
Right.
But on the role, obviously Indian courts are standing solidly behind arbitration, international arbitration and domestic arbitration. But Geeta, as a senior advocate with an extensive practice and interface with the courts, do you think the Indian courts have come far enough? Do you think they've hit the sweet spot, or is there still work to be done in terms of supporting arbitration, supervising arbitration in the most optimal way possible?
See, given the place we are in at the moment, I think we've come far. We've really come far. Both the amendments to the Arbitration Conciliation Act, repeated, he says it's nimble. I agree it's nimble, but it's also gives a feeling of non-continuity. So there are two aspects to it. And also the court system, sometimes we talk of public policy, wider interpretation, then we give a narrower interpretation, and so on and forth. Once we say we won't modify awards, then we say we will partially modify awards. I think it's all progressing towards a better arbitration regime. It's definitely improving. Question is, you're a small country. We have to go by your example. You took the best practices of all the countries, all parts of arbitration everywhere, and you've managed to bring it into India, to Singapore. I think India needs to bring that to a large extent. We've still need to work on emergency awards. We've recognized foreign, the enforcement of awards, we still need to bring that in. We, again, ARB has come into various, it's come in ICA, it's come in Mumbai, it's come in DIAC, but the enactment still has to keep in touch with that. So I think there are many aspects where we've made wonderful progress. Now, arbitrability for India, matrimonial law, insolvency, all these are a complete no-no. Even intellectual property, we have very restricted forays which we've started in intellectual property. So the question is that I believe that a greater training of lawyers and judges is perhaps, see, we've even dealt with the economic aspect, the financial liability of arbitration, which was becoming too much, the neutrality, the disclosure, all that has come in. But I still think perhaps the arbitration ethos and more acceptability by the judges is needed at the 34th, 37th stage. I think once we get that, we are really going to be finally there.
Thank you. Thank you. I'm going to turn to Dr. Pinky Anand. Pinky, what is your perspective on this journey of reform and cataclysmic change in India, especially from a perspective of a former Additional Solicitor General? What could you say?
I have 3 comments. Geeta has outlined some of these issues. The first comment I really have is I think we have progressed substantively legislatively. So legislatively, we've institutionalized, we have brought into view amendments 15, 19, 21, when we have a current arbitration bill pending, which brings in emergency arbitration statutorily, which talks about an arbitral tribunal, which talks about yet further expedited processes. So I think we are well on way legislatively. What I do think we have a problem with is the judicial side of it, and I'll tell you why. While courts in India have been viewing, Kiranji brought it out very well as an outsider, actually there's narrow interpretations of interference in arbitration awards and similar kind of ADR techniques, but nonetheless there is ambiguity at times, and there is constant evolution. Now, evolution is very good, progression is very good, but at the same time we need to cap it somewhere, and we haven't reached that state. So I'll give you 3 examples. For example, the Stamping Act provision of the stamping of the agreements. For example, the group of companies doctrine that was evolved. Now, this creates a very new field, but at the same time starts yet another dimension of discussion and dialogue which we can't afford, not in this commercial world. So I think this part needs to be covered up, patent illegality. Sometimes you're going in one direction on a narrow construction, sometimes on a wider construction. So we really have to make up our minds and put the formulas. Fraud, for example, Swami's judgment which Justice Sikri was mentioning, whether fraud should be arbitrable, not arbitrable, what degree of fraud. So we've got to start capping and saying, all right, here we've come to the end of discussion, and now we'll translate this into active practice. So that's one part of it. The second comment that I thought I would share with you is basically, I think we need a different regime for international commercial disputes. We really have to take the SICC route, which has come into play and is being followed by various jurisdictions. So not only ADR as in distinctive, but a separate dealing with commercial disputes on an international front. Similarly for the Arbitration Act. Now, our Arbitration Act is neither unitary nor it is binary. It is somewhere a cross between the two. So we have part 1, part 2, and there we are trying to deal with the differences again create a lot of ambiguity into international arbitrations. So I think if we can narrow down that surface and bring international arbitration into totally different domain, limit our various avenues of appeals, maybe make it a single appeal. I know this might be resisted by a lot, and I'm not speaking on behalf of the government for sure at this point of time. This is my view. But I do think if we need to cut it down and make ourselves an arbitration hub, we will need to narrow down the circumference. Nobody is going to accept, particularly in bilateral investment treaties. That's yet another domain you talked about, and I just wanted to add there. I do think we need to look into what we are doing. We started with an era of very wide. We ran into trouble, we ran back. Now, we've got to reach out again. We've started out, but the process has to be fast-tracked because we need investment into India. We have good. I know Singapore has 14.95 billion as we speak in 24-25, so there's no dearth of it. But at the same time, we do need additional 6 trillion, as Mohit pointed out. So this is what the figures we need to keep continuing the same growth that we've been having. So I think with these comments, Francis, I basically feel we can go a long way if we review our thoughts and quickly and fine-tune them into a certainty.
Thank you. Thank you. So, ladies and gentlemen, we've just been informed that we have a hard stop in a very short while. So if you have any burning questions, you need to raise it now. But what I'm going to do is I'm going to, the India-Singapore corridor, apart from, ADR, we also have cooperation in the area of conferences. We are going to give a couple of minutes to President-elect of the Inter-Pacific Bar Associations, with which I see as a deep relationship with. Pritisuri, I think you have a mic. Can you tell us about your upcoming conference? It's a commercial break.
Thank you, Francis. Hello, everyone. Very happy to be here. Really want to add more to what you're saying, but being very mindful of the time. IPBA is the only organization which is focused on Asia Pacific. So you have the IBA, you have various other organizations of bodies of lawyers, but this is the only one that's focused on APAC. And it's coming to India in February of 2026 after a gap of 14 years. It's an organization that has been in existence for 35 years. So I will encourage everybody over here. I think a large part of this conversation can actually be continued both next month when IPBA Arbitration Day is taking place in Mumbai. And then in February of 2026, we expect about 1,000 lawyers from around the world. Francis has already had 1,400 lawyers in Singapore back in 2019, so can't really try to match that. But I do think it's a great opportunity to continue the conversation. There will be, we have 27 specialist committees, and then there are lawyers, decision makers, senior partners, judges, in-house counsel, all of who actually come together and, talk about issues that are burning and how that can change, both from a business as well as from a disputes perspective. So I'll encourage all of you, go and check out www.ipba.org. You'll learn about the event next month as well as the one next year. So please join and come and be a part of a great conference in Delhi. Thank you.
Thank you. Thank you. Now, last question. Sean, very quickly, what are the key elements you want to highlight? At the end of the day, an award is as good as its enforceability. In the enforcement arena, give us the quickest answer possible. What changes have you seen?
Okay, from the Singapore context, it's actually quite exciting for us because there's just so many cases that have been seated in Singapore. And what that also meant is a significant number of these challenges go to before the Singapore courts and the SICC. And, there's always a nice enforcement fight, but there's always a nice point that comes out. So I wasn't going to sort of like give a summary, but, this little booklet that you have, which Kirin spoke about, it is a great summary of, the sort of enforcement issues we've been facing in Singapore. The one case I will always commend to everyone, for bedtime reading, if you struggle to get to bed, but actually it did keep some of us awake, is India against Deutsche Telekom. It is a great treatise on enforcement of arbitral awards where, potentially you have issue estoppel. You also have issues relating to what's called the primacy principle, transnational issue estoppel, so I will commend it for bedtime reading for enforcement issues. It's very well written. I think it's just part one. There are probably part two and part three coming up, but I think it also reflects the fact that these are quite exciting times for Singaporean lawyers like us because it does keep us busy. So I will always welcome an enforcement fight because, as I said, it does pay the bills for law firms.
Thank you, Sean. I'm going to hand it back to Mohit to wrap up.
So I just want to basically just make two comments which are probably relevant here. I think today we understand a lot of disputes will get to arbitration, mediation. I think, but there's an important part is this is like a demand, that there will be more demand for disputes to get resolved. But I think the government can actually work a little bit on the supply side. I think because less disputes actually arise. And that is an important thing which a lot of people here should think about it, because really our Contract Act is 1873. It's an old Contract Act. The way the damages are defined is very poorly, and therefore, it's not difficult if you breach a contract. The damages which will be eventually paid by Justice Sikri, he has to follow the rules. Indemnity can be considered penalty. So that's a big challenge, and therefore actually everybody uses it for delaying. And I think that's one amendment which probably required. And I think going back to Pinky Ji's comment about that you require a little bit better structure on international commercial arbitration, even domestic commercial arbitration, I think you require a very good structure, because really contractors like he represents, they all add to the cost of litigation in the cost of bidding. So therefore, to get a competitive infrastructure, I think you need a very smart, efficient arbitration, even for domestic. With that, we come to an end. Thank you very much. I will hand it back to the chairperson. Yes, to the master of the ceremony.
On behalf of ICA, I would like to extend my heartfelt thanks to our chair, Justice A.K. Sikri, our moderators, Mr. Mohit Saraf and Mr. Francis Xavier, and our distinguished panelists for sharing such valuable insights today. and to all the guests and our participants for joining us. Thank you so much. We look forward to continuing this dialogue and working together to strengthen ADR frameworks for future. While this session concludes, the deliberations continue beyond, and we now warmly invite all of you to join us and also I request all of you to please, all the panelists for a picture, if we can. And Justice Sikri and Mr. Arun Chawla can also please join us for a picture. And Dr. N.G. Khetan, please join us for a picture. I request all of you to please join us for lunch